Welcome, innovators, to a critical lesson that separates successful patent entrepreneurs from those whose patents collect dust. I'm Julie King, and today I'm revealing the terrifying truth that owning a patent does not automatically give you the right to sell your invention. You see, a patent is a legal shield, a right to exclude, not a sword you can wield freely in the marketplace. This is a patent paradox. When you secure a U.S. patent, the government grants you the power to exclude others from making, using, or selling your specific invention for a limited time. That's it. It's a purely negative right. Many inventors make the grave mistake of assuming this shield is a license to operate. They invest thousands in manufacturing only to be slapped with a cease and desist letter from a different patent holder. This is the horror of overlapping patents. Patents rarely exist in a vacuum. Most new inventions are improvements on existing technology. If your invention incorporates a single component, material, or method that is already protected by an active prior patent, you are infringing, even if your overall product is totally novel. Here's an example. Imagine you invent a revolutionary smartphone case that extends battery life using a patented energy-efficient chip. You successfully get patent A for the overall design and the function of your case, but the chip itself is owned by a competitor under patent B. You're now in a legal bind. You can stop anyone from copying your case design, which is for patent A, but patent B prevents you from manufacturing and selling the product because you're using their chip without permission. Here's how to avoid accidental infringement. Your freedom to operate checklist. Before you spend a single dime on mass production, you must confirm you have freedom to operate. This is your insurance policy against a devastating lawsuit. First, conduct a freedom to operate search. This is different from a simple patentability search. A freedom to operate search looks for active, in-force patents that your product, when manufactured and sold, might infringe upon. It's a proactive defense against infringement claims. Second, seek legal analysis. A patent attorney must analyze the claim of any blocking patents found. They'll determine if your product truly falls within the protected scope of a prior invention. Third, negotiate licenses or cross-licenses. If infringement is unavoidable, you must obtain the license from the prior patent owner. In some cases, if your patent is valuable to them, you can negotiate a cross-license where you trade rights to use each other's technology. Alternatively, you can seek to buy the patent rights from the other owner. Number 4, your other option is to design workarounds. The simplest solution is often the best. Modify your product to use a non-infringing component or process. This is the difference between a minor design cost and a multi-million-dollar lawsuit. Once you're legally clear to operate, the fight is not over. You have to turn your idea into a thriving business, which involves managing contracts and protecting your idea globally. You must have a robust contract with your manufacturer that includes strict confidentiality clauses and IP ownership clauses. You want protection against their employees stealing your idea. But then we come to the knockoff scourge. If your product is manufactured overseas, especially in places known for IP laxity, expect it to be knocked off. Your U.S. patent is a powerful tool to enforce at U.S. customs blocking imports, but it grants you zero protection in countries where you haven't filed for patent protection. If you plan to sell abroad, you must file internationally. As I've mentioned in other posts and will cover again, any marketing firm you hire or any materials you create must be legally sound. Watch out for accidental trademark infringement, such as using another brand's name or logo or something too similar to it. And what's more frequently a problem are copyright issues, such as using protected images or music in your marketing materials. And then we have the silent killer, market apathy. Even after you clear the legal minefield of overlapping patents and make sure you're not committing trademark or copyright infringement as well, there's no guarantee of success. A patent is a legal shield against competitors, but it offers absolutely zero protection against the much more common killer of market apathy. The U.S. Patent and Trademark Office grants patents based on novelty and utility, not on profitability or consumer demand. Many brilliant inventions simply fail to catch on, either because the timing is wrong, the cost is too high, or consumers just don't care. The chilling proof of this reality lies in the USPTO's own records. A large percentage of patents are allowed to expire prematurely because the owners chose not to pay the mandatory maintenance fees. These fees are substantial and are required 3 times over the life of a patent in the U.S. at 3.5, 7.5, and 11.5 years. If an inventor determines that the potential future income from the patent is less than the cost of the next maintenance fee payment, they'll let the payment die. The invention might be technically sound, but the market determined it was not commercially viable. The final lesson is grim but essential. A patent is a valuable asset, but it is not a business plan, nor is it a stamp of consumer approval. You must protect your invention legally, but you must also validate your product commercially before you commit to the multi-year cost of maintaining your exclusive rights. The bottom line is, owning a patent is an achievement, but it's only the first step. Before you invest in manufacturing, invest in a freedom to operate search and analysis. Protect your invention from your competitors, and protect yourself and your business from accidental infringement. Make sure that patent application is likely worth the investment of time and money by doing careful market research. You want to make sure your invention is market ready? Consult with a patent attorney to assess the legal landscape before you invest in manufacturing and sales. They can also advise you about how to protect your invention's secrecy when you do work with market research experts, so your work with them doesn't cause you legal headaches. Intellectual property is one of the most terrifyingly useful tools you have. If you're a creator or other entrepreneur ready to build a frighteningly powerful brand, you need to know how to use it. But you don't have to face the darkness alone. To learn more about protecting your creations, your name, your business, and your legacy, you can book a consultation with me, Julie King, at kingpatentlaw.com. I help entrepreneurs across the U.S. make smart, legally sound decisions about their intellectual property. I'm an attorney in Champaign-Urbana, Illinois, and I serve intellectual property clients nationwide. If this episode helped you to survive the horror of learning about how to protect and manage your intellectual property and business, please like and subscribe if you haven't already. You can find all my other frighteningly good content on the King Patent Law website, at Know Your Rights, Your IP and Business Law Playbook, on all major podcast platforms, and at King Patent Law on most social media. The information provided in this episode is for educational purposes only and does not constitute legal advice or form an attorney-client relationship. You should not act on any information presented here without first seeking the counsel of an experienced, licensed attorney, perhaps me, for your specific legal needs.